Hi, I'm Tim Naftali. I'm director of the Richard Nixon Presidential Library Museum in Yorba Linda, California. We're in New York. It's September 30th, 2011, and I have the honor and privilege to be interviewing Richard Gill for the Nixon Oral History Program. Dick, thank you for doing this.
Well, appreciate you doing it, recording it.
Tell us, take us into the early 1970s. What are you doing at that point?
I was a practicing lawyer in Montgomery, Alabama, with a medium-sized firm by Alabama standards, 14 to 15 lawyers, and practicing civil trial law. So life was just on course. I had finished a stint in the Army and come back to practice with that firm, and so that's where I was.
Where'd you go to college?
Went to Vanderbilt.
And where'd you get your law degree?
The University of Virginia.
Did you clerk?
I did not. You have to remember the time. It was the military requirements were pretty stringent, and so I had been an ROTC officer and had to serve in the military, and I was offered a clerkship by Judge Frank Johnson and had accepted it, and then I got an Army assignment, and I couldn't get another deferment because I'd gotten one to go to law school, so I missed that opportunity.
How are you recruited for the impeachment inquiry?
Judge Johnson is the key to that too. John Doerr and Judge Johnson were friends. John had been with the Justice Department during the Freedom Rides and various disturbances in Alabama, in Birmingham, and other places. And John wanted a national staff for the impeachment inquiry, as opposed to just a Washington group of lawyers or a New York group of lawyers. And he called Judge Johnson, who called me and said, "Are you interested?" They wanted a young trial lawyer. They couldn't pay a lot of money, so it kind of had to be young people for the most part. I guess I was 34 at the time, and Judge Johnson recommended it. He said, "If you get a chance to work for John Doerr, it's a chance of a lifetime," and so that's how I got introduced to John.
Roughly what period? Was it January of '74?
This right, it would have been early winter, and I came to Washington to get interviewed, and actually I talked to John on the telephone, and he said, "Look, if Frank Johnson recommends you, you've got the job." And I said, "Well, what is the job?" I didn't know, and he said, "Well, come on up, we'll see where you might fit in." And because I was far enough along in law practice, and I had a new child, and was married, and I didn't want to come up and do a clerical job, frankly. And so I came up, and John said, "No, what I have in mind for you is to head up 2 of the task forces," and said, "When can you come to work?" I think I interviewed him on a Wednesday, and he interviewed me more accurately. And I said, "Well, I'd need to go home and arrange things with my law firm and my family." And he said, "I'd like you to come to work tomorrow." I couldn't, obviously, but I did actually the following Monday. I went home and met with my partners and parceled out cases, and they said, "We'll take care of it. This is something you ought to do. You won't remember a lawsuit that you handled 10 years from now, but you'll remember this for a lifetime, and go, we'll take care of it." So they said, "We'll supplement your pay because they can't pay you much."
Did you have any idea when you accepted the job how long this job would last?
I didn't. It was open-ended. We didn't know how quickly the political process would move, and it was interesting. I was a lifelong Republican. John Doerr, of course, is a Republican. Was then and still is, as far as I know. But he said, "I want you to work on the majority staff," and so he said, "There are not going to be any political affiliations. That doesn't matter within the staff. What you're here to do is to be a lawyer." And so I did on that Friday go see Judge Johnson to tell him, and I remember being very cautious and saying, "Judge, I voted for President Nixon, and I just think we ought to start with a presumption of innocence. And he said, well, that's good. And, you should do that. And of course, at Easter time, after we had heard the tapes, Judge Johnson always told the story that I came back to see him and said, Judge, we've got the bastard. And I don't think I actually used that phrase, but that's what the judge reported in some talks. And, so we didn't know, and I had nowhere to live. My senior partner had a daughter and her husband who lived in Alexandria, and they offered me a attic room in their house until I could find an apartment for my wife and son, and so that's how I got here.
When you arrived, which two task forces were you given?
I forget what the formal names were, but essentially one of them was the plumbers units and the various wiretaps of journalists and others, that group of facts, and then the second one was the sort of political matters that were characterized as being associated with Donald Segretti. Sort of political dirty tricks maybe have been the sort of semi-title of it. Now,
did you have a chance to recruit your teams, or were the teams already set for you?
Half and half. There were a good many people already in place. Dick Cates was an extremely skilled trial lawyer, and he was sort of assigned at the next senior level to help get the fact-finding parts of the task forces organized. But then others applied for jobs, and we interviewed them. The assignment of people to the task forces really was done by Dick Cates, John Doerr, maybe by Bernie Nussbaum. So I didn't really recruit specifically for my task force.
Can you tell me the names of some of the people who were working with you in this task force?
Well, of course, the one that is the most unusual was Hillary Rodham. She had just graduated from law school the previous spring and was a junior lawyer and applied, and she was initially assigned to my task force. She later, because she could accomplish things quickly, she was spread out into other areas, but she was, and Lee Dale from Colorado, from Denver, was on my task force, and the Republican, he was assigned to the minority staff, was a fellow named John Kinahan, who had been an assistant U.S. attorney in Virginia, I think. And then I'm trying to think who else in the structure. I don't know, it'll come to me.
Well, let me ask you a bit about the structure. You mentioned minority staff. Was there a minority staff on the plumbers task force?
There was. There were minority staff members assigned to all of the task forces, so that everything was covered politically, if you will, because the committee was structured into a minority and majority, and everyone wanted to have appropriate representation, so it couldn't be accused of being a political focus as opposed to a kind of legal focus.
When your task force would meet, did you caucus together, or did you have a separate caucus for the majority staff and one for the minority staff?
No, we just worked seamlessly, really. If there were tasks to be done, whoever was available to be asked to do it did it. I know we were asked to go to California at some point and interview the prosecuting attorneys in connection with the Ellsberg break-in, and John Kinahan and I flew out there together so that there was both a majority and a minority staff person present. But it really was not structured that the minority staff met and the majority staff met at all. It was meshed all along.
Now, when you started, the decision had already been made not to do more investigations, or were you there when that decision was made?
Well, you see, I'm not even sure that that decision held throughout. In fact, I know it did not. We were confronted with a mass of materials that had been assembled by the Senate Special Committee that had never really been digested, organized, collated, integrated into the whole fact pattern. and I don't remember, I know the number was in 6 figures of pages of materials, and so that was the initial thing that confronted us. But early on, a number of us pushed for further investigative work, interviewing witnesses, the business of going out to California as an example, but we ended up getting permission to interview most of the Plumbers people who could still be reached, who mattered. I mean, Liddy and Eagle Crow and then Charles Colson. And so we did that. And so I don't think the decision to not do further investigative work really held for very long. And I don't know how that decision was reached. To start out, it made sense. Let's see what we've got and digest that, but it did grow from that.
I know it's been a long time, but what were some of the questions right in the beginning when you were digesting the Plumbers' information? What were some of the questions that you had?
Well, we always had to remember what our job was. And our job was not to prosecute the Plumbers or to be involved in that at all. The question was there evidence of presidential involvement? And if so, was it constitutionally and legally proper or not? And the or not was always there. Dorr made it absolutely clear that this is not a witch hunt where we start out presuming the president is guilty of anything and we're going to start and try to prove our preconceptions. He said we're in investigation, we're going to give the straight answers. So we started out looking at the Plumbers. The wiretaps were the most sort of top of the pyramid thing that had reached public interest, because it was known that there had been a number of people on whom domestic wiretapping had been carried out. They didn't know who. That was a lot of speculation about that and why, and didn't know on what authority. So that was one. The break-in into...
Let's just stop for a second, please. This room has its own set of noises.
Still speaking.
Okay.
The break-in.
Well, the break-in into Ellsberg's, the psychiatrist in the Ellsberg case, and it turned out there were, of course, the break-in into the Watergate itself was Evan Davis's task force and the cover-up of that. But it was carried out by the Plumbers unit, so of course there was an overlap between those two matters. But we didn't know how much domestic spying and surveillance had been going on and how it came to be authorized. And of course, ultimately, that misuse, if you will, of the CIA and the FBI to carry out political surveillance was one of the impeachable offenses. So that was a major focus. I always thought the Segretti business was a sideshow, and as it turned out, it really was. It was perhaps childish stuff. It was annoying, but it didn't amount to much.
How often would you see Mr. Dorr? Did you have sort of open-door access to him?
Yeah, you did. Now, we tried to respect the fact that he had important policy-level things and dealings with the committee and to do. And we shouldn't annoy him with daily questions. He expected us to carry out the kinds of investigations and analyses that lawyers are supposed to be able to do. We did need his permission if we were going to, for example, interview Gordon Liddy. Liddy was in prison in Terminal Island, California, and it took some maneuvering to get the Justice Department, the FBI, and the Bureau of Prisons, and I don't know who all, to transport him to Washington and make him available to us. So, and only John, frankly, could pull that off. we had the same sort of interface with the Justice Department over getting the actual transcripts from the domestic surveillance. Justice Department and the FBI didn't want to let us see the raw transcripts. There was a relevance reason why we thought we should see them. And we had to go to an assistant, I don't know what his title was, named Silverman at the Justice Department that John knew, and put pressure on him to do it and set conditions. I couldn't have carried that out as a junior. I mean, my title was, and so was Bob Sachs and Evans. We were, quote, senior associate counsel, but we weren't very senior. We were in our early to mid 30s. And and we had no independent authority to force. And the committee tried not to issue more subpoenas than necessary. I'll tell you the story when we get to it about the confrontation with the Justice Department and how John got that resolved. It's kind of an interesting story in itself. But so we did have to involve him. We wanted to interview the judge, Judge Matt Byrne, who had presided over the Ellsberg break-in trial, and who had been approached by the president. He didn't want to be known to be interviewed by us. John arranged for him to come to Washington on a Sunday, so no one knew he was here. And but again, I had to tell him that I thought that was something we needed to do, and if he agreed that that was a task that ought to be carried out, then he had the authority and could make the arrangements to get it done.
Before we go and talk about the subpoenas, you mentioned to me it's important to understand the distinction between a litigator and a trial lawyer.
Yeah, I guess I've been a trial lawyer for now 46 years. Trial lawyers who actually spend their days in court, or some of their days in court, have a different view of how you get evidence and how you present evidence than people who engaged in litigation but do it primarily through motions and requests for production and briefs and that sort of thing. And those who are litigators, they're in the litigation field as opposed to a business lawyer or a tax lawyer. Dick Cates was a superb litigator. He knew how to analyze facts, knew how they would fit together, knew how they would present as a logical sequence. I was a much more junior trial lawyer, but that's why I was chosen. I mean, Judge Johnson was asked to find a young trial lawyer. The trial lawyers on the staff wanted to do interviews, wanted to get people's specific statements and testimony down if we could, not just go on the papers. And as I said, ultimately there was a good deal of that was carried out. Initially, the thought was we can go on what is in the documents, the memoranda and the correspondence and all those things. But it didn't turn out that we could. I didn't think we could, and I think that ultimately the actual people mattered.
Well, so you didn't know how much had been destroyed.
That's right.
Of the documentary record. I mean, you had people under oath who had admitted to destroying material.
That's true, and I assume we'll get to it, but of course, there's the famous incident of the recordings and the Nixon version of them versus the actual version. But the same thing happened with John Ehrlichman's notes, and I'll tell you that when we get to it.
Why don't we do it now?
Well, John Ehrlichman, as I know you know, was a prolific note taker of all his meetings with the president, and he had a kind of shorthand that allowed him to get a lot of information into small bits of paper. I mean, they were voluminous, but he had a personal shorthand. We wanted to see those notes as they related to meetings with the president. And you have to remember, we had access to just 6 tapes initially, and there was the rest of the tapes really were delivered after the president resigned. So there were clearly gaps in information on the tapes, and trying to piece together things, we said there's another source. John Ehrlichman was present and took notes. The White House did not want to turn them over, and we actually, it was kind of a funny event. We asked the special prosecutor's office, who was very careful to keep a boundary between the congressional side and the prosecutorial side. But they had subpoenaed and had custody of Ehrlichman's notes. We requested the White House to give them to us, and Mr. St. Clair and his staff equivocated for a while, and finally they said, well, we'll give them to you. But we went on, they said, you have permission to see them. I've forgotten, there was a funny phrase that was equivocal. So we took that phrase and asked the special prosecutor's office to give us their copy. And they did. And at the same time, almost the same day, I'm pretty sure it was the same day, the White House sent over what they said were the Ehrlichman notes. And they found out we had the whole set. And there was a big hoorah, and they demanded that we return them and this, that, and the other. They came to me. John was in a hearing or some proceeding before the committee, and this demand came that we return them. And I didn't think I was going to return them, but I certainly wanted him to know, because it was clear that the two didn't match any more than the two versions of the tapes matched. And so I sent a note over to him in the hearing room, and he sent back a note that we were not to return the full set. And when you analyze the Ehrlichman notes, Dick Cates said, and I think he's right, that without the tapes and without John Dean's version, you could have made the same case using the Ehrlichman notes. They didn't play as big a role because you had tape recordings of many of the same meetings, so the tape recording was a better tool or an easier tool than the notes themselves. But there were lots of meetings recorded in Ehrlichman's notes that we didn't have in the tapes that were then available to us. So they were very important. But we did get an altered set from the White House, and but had this coincidence of getting the full set.
From the special prosecutor?
From the special prosecutor's office.
I'd like to just walk you through this a little bit, if I may. When you say an altered set, are you saying that there were omissions, or are you saying that there appeared to have been notes that were...
I think omissions is the more accurate word. There were clearly pieces taken out. I don't think there was any fabrication of entries. I never saw that.
Tim, could you just shift a little to your right? I'm just getting a little bit of your shoulder when you just shifted. Sorry.
Okay.
Thank you.
Tell us a little bit about your relationship with Dick Cates, please.
Well, I'm a great fan of Dick Cates. I have to tell you, he's just a fabulously funny and bright man. Had great instincts about evidence and trial. I remember he predicted to us what would be in the tapes that we didn't have when we finally got them. He said, I can tell you from the events that happened here and the events that happened there, what has to exist in between. And sure enough, there it was. Once you got the rest of the tapes, those gaps followed Dick's analysis, that it had to be there in order for the second event to have occurred the way it did. And he was a charming man, and he almost charmed Gordon Liddy into giving us some information, but we didn't quite succeed. That's a funny story too. But
go ahead.
Well, we wanted to interview Liddy. He was head of the plumbers unit, and clearly he was more knowledgeable about the connections to the White House. The people who were known as the Cubans really were not. They were the workers and the door openers and all that. And so we did ask the Justice Department to bring Liddy from California. He was awaiting his appeal. He'd been convicted on a number of things and had appealed his conviction, but was not released during the appeal. And so he was brought to Washington, and I thought, you know, they put him in the D.C. jail that everyone referred to as the Black Hole of Calcutta. And we thought, we're trying to get the man's cooperation. This isn't helpful to do that. But anyway, they let him out for a day and brought him through the tunnel system under the Capitol to our offices in the old Congressional Hotel, and so that the press wouldn't know he was there and all that. And he signed in. We had some security, and he signed in and said, under protest. So when we got back to interview him, and it was Dick and me and Liddy, he said, Dick asked him, why did you sign in under protest? What's the nature of your protest? He said, well, you're government agents, and I'm being interviewed without my lawyer, and that's a violation of my rights. And we said, well, we're not interviewing you for purposes of prosecuting you. We don't have any authority over you at all. And in fact, we're not even prosecutors in the ordinary criminal sense of the word. But if you want to call your lawyer and see whether you can talk to us, we'll give you an office and a telephone. His lawyer was in New York. And Dick Cates says, and we got some lunch for you, you know, get you out of that D.C. jail, and got you some cigars, because Liddy's always seen with a cigar. And Gordon Liddy said, oh, I don't smoke those things. It's just a prop. Said it makes me look tough, but he said, I don't actually smoke cigars. And so he went in next door and called his lawyer and came back and said, well, my lawyer says not to talk to you, not to give you a statement. And Kate said, but Gordon said, just think of what you could do for us. Said, you'd make me famous. He said, what do you mean? He said, I'd be known as the man who cracked Gordon Liddy. Then don't you want to help me? And so it had that kind of, and I remember asking Liddy, wasn't he frustrated because his appeal had taken so long and he was still jailed? And I said, you know, if I were waiting in jail and I thought I had a valid appeal, I'd be just sort of beating my head on the wall in frustration. And he gave this sort of Zen answer and said, there's no point in beating one's head against the wall unless you have a reasonable expectation of knocking the wall down. I thought, oh boy. But anyway, we said, well, you're here. You might as well have lunch. You might as well enjoy the day out of the jail. And so we talked to him about the New York Yankees and this and that and the other, just trying to, you know, get him to. He's a pretty clever man, and he's a lawyer, and you know he was worked as a prosecutor himself, and so he really couldn't be fooled or conned into giving us anything. But the next day, he filed suit against us, named Cates and me as having violated his rights to be interviewed without counsel, and wanted all the charges against him dropped. And it was assigned to Judge Gerhardt Gazelle at the District of Columbia Federal Court. And so Burt Jenner, who was head of the minority staff, said, well, I'll be their lawyer. They said Cates and Gill don't need to be their own lawyers. And so he got an appointment with Judge Gazelle, and he told me, he said, come on, we're going to go down there and get this foolishness dealt with. So we go down to the courthouse and meet with Judge Gazelle, and he says, I'm going to throw this thing in the trash. Don't worry about it. He and Jenner were old friends, and I think Jenner had probably been head of the ABA and got help with his appointment. But I'm just sitting in the back of the room. I'm the junior guy on the wall. And but he says, don't take up any more. He says, that thing will be in the can tomorrow, so just go on back to your work. So we marched off, and that was the end of Liddy's lawsuit.